Good afternoon, everyone. Thank you. Thank you for coming at this time of the afternoon. We are really very happy to be having this afternoon session all together with you, and we are really looking forward to the discussion. Before I continue with the thanks words, I will explain you how we will organize this session, which is the 4 speakers will talk in a row, and then afterwards we will open the floor for discussion. But from the very first moment, you can already send your questions or ask for the floor. So before I introduce these speakers of this afternoon, my dear speakers, I need to say thank you. Thank you to the organizers. This is an impressive event in all kind of senses, and we are all very happy to be here in Girona, sharing this venue, sharing the time with you, and listening to the interesting discussions yesterday, this morning, and the days that are going to follow. Thank you very much for the audience, again, to be here presently, but also those who have connected remotely, which is a huge number. And special thanks to Jordi Ferrer. Professor Ferrer, thank you for asking me to organize this panel, which has given me the opportunity to put together a bunch for excellent academics, excellent scholars, excellent persons, I would say, creative ones, and surely they have made me very happy just accepting this invitation to be in this conference. There's only one shortcoming, and it's only attributable to me. My blame, and it's not the fault of anyone, but it turned out to be like this. There is no exact gender balance in this panel. So I'm sorry, but they are all very much aware of women's rights, so I hope this can balance it. So now that I've finished with the thanks talk, the idea of this panel was to introduce cross-cutting topics on evidence from very different angles, to try to figure out whether there are differences in the different areas of law, and obviously with the input from philosophy too. So it has been designed, this panel, to give an insight on evidence and what bridges and what is blurring or what is closer in torts and criminal law. And the second speech is in different procedural models and how evidence is handled, and if there is a trend to approach or to separating and with regard to evidentiary issues. The third topic is a very much interesting one, which is the probabilities and risk assessment, also not precisely on trial, but in the preventive law. And the last speaker will talk about evidence from the point of view of a philosopher, but taking also into account the legal view. So I would also present my own topic, my own cross-cutting topic. Don't be afraid, I'm not doing it, as I'm obviously very much interested in evidence law, but my point will be on evidence out of trial and the intersection or interaction between intelligence law and criminal prosecution, something which is very actual right now, which is also private evidence, private investigations in international criminal justice. And finally, my topic will be on how evidence is to be presented in order to assess the waiver to the right of presumption of evidence. But it's not my turn to talk today, so I will give immediately the floor to the first speaker, and I'm sure you won't be disappointed by this panel this afternoon. So please don't go into siesta mode, and we are not seeing you very well because of have a strong light here, but we will try that you keep awake and listen to these very interesting speeches. So our first speaker this afternoon, Professor Matthew Dyson. Matthew Dyson is Professor of Torts and Criminal Law, but I know and I've heard him teaching also in European law, Roman law, legal history, so I would say he's a Renaissantist legal scholar, and he's presently full professor at the University of Oxford. He's member also of the College Hill, which is one of the leading criminal law chambers of barristers in London. He has been visiting scholar and visiting professor in numerous universities, among those I can name Paris, Cape Town, Iowa, Göttingen, Sydney, Harvard, and I won't continue because it's too long a list. His publications have focused in criminal law, but also in tort law, the relationship between them and the comparative perspective is also present in his works. I will name just a few. Unraveling Tort and Crime, published by Cambridge University Press in 2014, Comparing Tort and Crime, Cambridge University Press, 2015, 50 Years of the Law of Commissions, Hart, 2016, and so on. So please, Matt, the floor is yours, and we will listen to your wonderful 20 minutes speech.
It's my very great pleasure to be on this panel organized by the wonderful Lorena, with excellent colleagues, and in a setting as wonderful and as important as this Evidence Week. I'm going to be drawing on research done over the last 15 years, research that looks at how and why the relationship between criminal law and tort law changes. I'm not an evidence lawyer. Indeed, such creatures are rare and wonderful, and I would not claim to be of that kind. But I will be telling you a few things from the perspective of a substantive lawyer. There are many threads that one could pick up, from the differences in procedure for gathering evidence, for admitting evidence, to the legal actors involved in using it. Many of these have to be left for another day. I will be using examples from criminal law and tort law, predominantly from England, but informed by other legal systems. The examples will be particularly from two places where direct comparisons between civil and criminal law are made in relation to evidence. They're interesting counterpoints because normally in England and in many legal systems we don't meaningfully probe the relationship between civil and criminal law. Those two areas are the standard of proof and the admissibility of convictions in later civil claims. The thread I want to draw out from this is that evidential rules are places where gaps or softness in substantive rules are processed, often hidden from legal scrutiny. They both unify and act as crutches to support incomplete substantive legal thinking. In addition to that headline, I think what I'm going to tell you about shows that legal reasoning on the identity of an area of law is complex and in England is largely driven by practical concerns. A great deal flows from the outcome, that since the state is punishing, we must require a high degree of certainty. I can also note that I think the more a legal system directly integrates its criminal and civil procedures, the more it will harmonize the content of those procedures. Or put another way, it's harder to justify divergence and complexity when you're dealing with a civil case inside a criminal procedure. I'm going to start with one potentially controversial opinion. I say controversial because there's two leading German lawyers next to me, and I'm pretty sure it's controversial there. In England, the identity of law as civil or criminal is not, in my opinion, grounded on deep principles. I am entirely unpersuaded that there are categorical grounds in our system, perhaps even in the common law in general, for saying that there is a sharp divide between civil and criminal law. In a system like ours, tort law can punish, criminal law can compensate. So even those functions do not provide an easy, if largely meaningless, distinction. Similarly, in tort law, in England, we can issue injunctions, not just compensation, and some tort claims are possible without the proof of any damage at all. I know that in Spain, the standard dogma is that tort law compensates and criminal law punishes. I'd love to be persuaded that that makes sense for England or in general. I'm going to turn to my first point, standard of proof. It's often thought axiomatic amongst common lawyers that the standard of proof in criminal proceedings should be two things: high, to justify state punishment, and able to be expressed to laypersons in simple terms. Technically, we ask for beyond reasonable doubt. But in practice, we ask the jury to decide, or the magistrate to decide, are you sure? But amongst common lawyers, there is much less force behind claims about proof in private law. It's still well settled that the test is on the balance of probabilities in English law, on the preponderance of evidence in US law. They mean the same thing. A preponderance is one grain in a direction further, the grain that tips the balance over. In practice, we do not articulate this in every case. We don't need to. And we actually very rarely discuss that the standard is higher in criminal law than in civil law. It just seems obvious from the greater state involvement in punishment in criminal law. There is good legal theory on it, but practitioners would not normally talk about it. One argument is that in tort law, who ultimately bears the loss is a zero-sum game. It's as onerous for one party as the other, so the risk of mistake should be equally borne. Generally, civil law has no other standards of proof when it comes to trial. Criminal law uses another standard, the same as the civil law, for certain discrete questions which the defendant will normally have to prove. The defendant is has the burden of proving by raising evidence. So in a sense, it's not really proving at all of certain questions like sanity. If you wish to claim you're insane, you merely have to raise evidence of it, which the prosecution would then have to disprove. Both areas of law recognize that some preliminary issues might involve something less than the full standard. In civil law, an application to strike out, remove a claim requires that the claimant cannot show an arguable case. In criminal law, an application of no case to answer, usually at the end of the prosecution's case, so halfway through the trial, has a similarly more difficult burden to show to end the case. Put another way, proceeding is easier than stopping. But interestingly, when a prosecutor is deciding whether a case should be proceeding to trial, they run the code test. That's the code for public prosecutors. It has two parts. The first part asks about the evidence, and the second part asks about public interest. The code test on evidence asks for a realistic prospect of a conviction, which the Crown Prosecution Service themselves say is effectively asking, is it more likely than not that there will be a conviction? So prosecutors use, in effect, a civil standard of proof to decide whether to proceed. That is the formal documentation, anyway. My experience of prosecutors is that they ask for more than that. But of course, for many in the room, it will come as a surprise that common lawyers are quite comfortable with judges deciding cases when they are not convinced personally of the truth in the direction they decide. But it's vital to understand that in English law, formally, neither in criminal courts nor in civil courts do judges directly apply the law of the other field. We do not have a joined-in process, a civil claim within a criminal prosecution, nor do any common law jurisdictions that I know about. The Adhäsionsverfahren, the adhesion process in Germany, the compensatory components of the French partie civile, the Spanish formulation of ex delicto liability, are all unknown to us. When an English criminal court awards compensation, which it does every day, it does so through a compensation order, a criminal order on a criminal standard of proof. In practice, however, there are other limitations. The compensation order is limited to the financial capacity or means of the defendant. They are typically for small sums. By comparison, the burden of proof is, at a very general level of abstraction, the same in civil and criminal law. The party putting forward the claim must prove it. English criminal law and tort law very rarely reverse the burden of proof of a fact which is part of the claim or offence. It almost only ever happens by legislation. Tort law does so rarely. It has little legislation for a start. It might do so where, in effect, it's an exit from strict liability, like the development risks defense in product liability. There is a general evidential rule called res ipsa loquitur, that the thing or events speak for themselves. However, this is not understood as a reversal of the burden of proof. It's understood as the claimant raising an inference, typically of negligence. We did consider in the early 2000s a situation which could have led to a reverse burden of proof and which does in some other European countries. That was in respect of mesothelioma, a type of cancer triggered by asbestos. But instead of what might be considered the intellectually dishonest form of reversing the burden of proof, when you know that scientific knowledge does not allow for the thing to be proven, we resorted to common law magic and just said that causation was proven. I don't know that that's any better. For reasons of time, I'm going to be moving towards my second heading, which is also smaller: the admission of convictions as evidence in later civil cases. English law originally prohibited convictions being admissible in later civil claims on the same facts. Famously, a man was in prison for having committed a robbery. He protested his innocence. A police officer said, "You did it." And the convicted person successfully sued in defamation the police officer who said he did it. This changed by legislation in 1968. Civil actions could admit as evidence convictions, and those convictions would be conclusive in one specific action, defamation. But this leads on to the problem of collateral attacks, where a civil party uses a later claim to attempt to undermine an earlier conviction. The conclusion of English law is ambiguous on this, but it appears to use the same general mechanism, which is to rely on the conviction being evidence and not to assess its value. The work is done by trial courts and finders of fact. In criminal law, those are predominantly lay people, non-lawyers. 95% of cases are dealt with in a magistrate's court, and the vast majority of magistrates' courts feature only lay people. The other 5% are feature juries, who are also lay people, normally. Interestingly, one of the reasons why convictions were not admissible before 1968 was because the rules of evidence were wider in criminal law than in tort law. So it would theoretically be possible that a conviction was admitted in a civil case based on evidence that was not admissible in that civil case. I'm turning now to conclude. The borders of areas of law show us valuable things. The seams between fabrics in the law show us how much we care about pattern matching. They show us where pressures in a system to promote homogeneity and uniformity run out. Identity, such as something being criminal or tortious, might possibly flow from deep substantive content. In English law, it does not appear to do so. The content is mirroring, in rules of evidence, the same questions across tort and crime, but ultimately requires a higher standard for deciding the case. When they cannot resolve a complex matter of legal principle, both areas of law reach out for similar solutions. They can treat the matter as one of evidence and defer to a finder of fact, or they can hide it under an open-textured concept like reasonableness. Legal systems can rely, as in England they do, on practical concerns, how to achieve or solve cases. And a very simplistic statement that state punishment requires a high certainty of fact is all they formally need for their decision-making. But it does seem to me that the more systems integrate their substantive components of law and the trials of their civil and criminal questions, the more likely they are to realize and respond to harmonizing pressures with the law. This is likely true for rules of evidence and procedure, as well as the standard of proof. Thank you very much.
Thank you very much, Matt. We really listened very carefully, so we expect the questions to be coming later. I have the pleasure to introduce the second speaker of this afternoon, which is very much known to many of you, and I can judge this by the number of times this morning I've been going around and people have asked pictures to be taken with Máximo Langer. So there's no need to present it to this audience, but Máximo Langer is professor of law at the University of California, Los Angeles, and in the United States, and he teaches criminal law, comparative criminal procedure, and international and transnational criminal law since 2003. He's also president of the American Society of Comparative Law. Congratulations. In addition to teaching in UCLA, he's also director of the transnational program on Criminal Justice at the UCLA School of Law, Fellow of the American Law Institute. He has also been the founding faculty director of the Criminal Justice Program at the same university, and he obtained his law degree at the University of Buenos Aires School of Law and his doctorate in legal science from Harvard Law School. He's the author of numerous publications on criminal law and criminal procedure, and his work has been translated and published in multiple languages. And I won't name all the awards he has been receiving up to now, but I'm sure you won't be disappointed neither by this second presentation. And having a background in civil law, education in Argentina, and then moving over to the common law countries, like in the States, I'm sure he's one of the best suited scholars to present these two models and legal traditions. So his presentation, his speech, the title, you have it there, but anyhow, Adversarial versus Inquisitorial, Blurring Borders in Evidence Law. We expect some answers. Thank you, Máximo, for accepting the invitation.
Buenas tardes a todos, a todas.
Good afternoon.
Professor Bachmaier for the generous introduction and for the invitation. Thank you also to Professor Jordi Ferrer-Beltran, Carmen Vázquez, and congratulations to all the organizers for this wonderful, wonderful conference in honor to the great Michele Taruffo. It's a real privilege to be here with you today. Lorena Bachmaier asked me to talk about, quote, adversarial versus inquisitorial, blurring borders in evidence law, and I'm going to do so by briefly discussing, with a very panoramic and broad view, this question, essentially concentrating in the United States, a few European jurisdictions, and also Spanish-speaking Latin American jurisdictions. And specifically the changes that these jurisdictions, or some of the changes that these jurisdictions have experienced in the last 4 decades regarding criminal procedure in general and evidence law in particular. In order to do that, first, we need to define what we mean by adversarial and inquisitorial, right? That was, again, proposed by Professor Bachmaier in the title of the presentation, but that, as we all know, they have very multiple meanings. I'm not going to talk about inquisitorial in a negative way. By that, I mean just what has been the traditional conception of criminal procedure and on evidence law regarding criminal matters in civil law countries. And I'm going basically to use two opposing pairs to try to capture at least some of the differences that have existed between the criminal process in common and civil law jurisdictions across time. The first of these oppositions is the opposition between the criminal process conceived as a dispute between two parties before a passive umpire versus the criminal process conceived of as a unitary and impartial investigation. This opposition explains, or at least captures, or reflects many of the features of the criminal process that we typically associate to the criminal process and to evidence, to the gathering of evidence, presentation of evidence, assessment of evidence in common and civil law jurisdictions. For instance, model of the criminal procedure as a dispute between two parties. How are the elements of proof collected there? Well, they are collected through two parallel investigations, right? The one carried out by the prosecution with the assistance of the police, and the one that the the defendant and the defense attorney with the assistance of an investigator may also carry out. How is the evidence presented at trial? Well, we structure the whole trial with a case of the prosecution and a case of the defense, and each of the parties present their own evidence then at trial. Interrogations of witnesses, expert witnesses, how they are carried out, also with a structure of a dispute between two parties with direct and cross-examination, redirect, and the like. There are many other things that we could try to associate, right, with these two opposing pairs, but for the time being, that gives you a general sense of some of the differences that these two broad pairs, this first opposition, right, between these first two categories may capture. The second opposition is more complicated, and I think that it requires probably some elaboration that I'm not going to do today. I am just going to use the opposition that my mentor, mi maestro, Miriam Damashka, articulated, right? Phases of justice and state authority, right, that was mentioned yesterday in the opening lecture. And this is the opposition that Damashka articulates between what he calls the coordinate ideal on the one hand and the hierarchical idea on the other. What is the idea there? Well, if the first opposition that I propose to you describes two different ways to structure the criminal process and then to gather evidence and to present the evidence and to examine the evidence and eventually to evaluate the evidence, the second opposition tries to capture how the civil and common law traditions have had a different conception of authority within the administration of criminal justice. And that done with very broad historical perspective, right, or from a very broad historical perspective. So, for instance, if we are talking about the hierarchical ideal, that one from civil law jurisdictions, in those jurisdictions, legal professionals exercise authority within the criminal process. They are in hierarchical relationships of authority between each other, and they apply technical rules in making decisions about individual cases. There are other features that we could also associate with this category. For instance, the idea of protracted proceedings, the idea that what happens in the pretrial phase, the gathering of evidence during pretrial phase is going to have an impact in the adjudication phase, right? It will have some value or some impact in the adjudication phase. The idea also at trial of a unitary court, right? There is only one court, right? And not two adjudicating bodies like in the opposite idea. The opposite ideal, the coordinate ideal, now, with typical Damashka's elegance, you can figure it more or less what it is, right? Administration of justice, the authority there is carried, right, is exercised by lay people that are in horizontal relationships with each other, that apply community standards in their decisions. There is the day, the trial day, right, the day in court idea, right, concentrated proceedings. And there is also there a bifurcated court, meaning a jury and a professional judge. If we talk about rules of evidence, I already talked about the gathering and presentation of evidence, interrogation of witnesses, and the like. But common law rules of evidence then, like, let's say, the prohibition of hearsay, can be then, or a more atomistic conception of evidence law, like the one we find in common law jurisdictions, could flourish, right, in kind of the first setting, right, that this coordinate ideal, right, tries to kind of capture, right, or describe. But historically speaking, we also know that things are more complex, right? Langbain's work, for instance, shows that actually rules of evidence, like the prohibition of hearsay, really were only fully developed, right, once lawyers started to participate in the criminal process on a regular basis, and once English law became then a criminal trial that is closer to the model of the dispute that I was describing earlier. In the reverse side, right, if we are talking about civil law jurisdictions, the principle that all relevant and useful evidence may be admitted at trial, and the principle of free assessment of the evidence, right, of libre apreciación de la prueba, and with also its more holistic conception of evidence, all of them fit in a model of the official investigation in which the criminal process emphasizes finding out the material truth, right, in order or before adjudicating the case. So once we articulate what I mean by these two conceptions, then we can explore the question that Professor Bachmaier asked me to address to you today. Are these two conceptions of the criminal process and of authority within the administration of criminal justice been blurring with each other? Have they kind of, mixing with each other, right? So that we don't have kind of, they are not oil and water, right? But they are actually some sort of a yummy mixture, right? Between, let's say, between two substances. And in that regard, the first thing to mention, as you know, is that actually these systems do not exist in isolation. There is a long history between them. And the idea that these systems influence each other, right, and that the lines, the law lines or the borders, right, as the title suggests, may be blurring, is actually relatively old. If we go back in history, we can go back to the French Revolution, French revolutionaries that decide to import the English system, right, to a great extent, with the English jury, grand jury, justices of the peace and the like. We can go to the Napoleonic Code of 1808, right, with the adoption, once again, of the jury system and of oral and public trials. Napoleonic Code that then became the model for many reforms in continental Europe during that century. Those ideas, you see, in a way, those reforms try to adopt some notions of the coordinate ideal and bring them to an administration of criminal justice in continental Europe that had been organized under the hierarchical one. What was the result of that? Well, there was some blurring of borders between them, right? In jurisdictions that before we did not have juries, now we did, right? Or then we did. But it's also important to notice that big strokes, right, big parts of the traditional conception of the criminal process and administration of justice in civil law survived that translation, right, of English institutions to civil law jurisdictions. So, for instance, the model of the official investigation very much still prevailed as a way to organize the criminal process in civil law jurisdictions during the 19th century. Investigating judges survived. The role of the presiding judge during trial, right, in determining the order of the evidence, examining witnesses and the like, also survived in many systems. And also, if we concentrate actually in features that we associate with the hierarchical idea, the idea of the judicial dossier and the idea of hierarchical structure, right, of the administration of criminal justice, still very much survive, right? For instance, we see it in the appeal systems and the like. If we look in the 19th century the other way around, meaning influences from civil law towards common law, it's possible to find some, right? I think that, for instance, professionalization of police or professionalization of the public prosecution function, right, could be understood as a result of the influence by civil law jurisdictions and the civil law tradition over common law. Let me now then forward 170 years or so, and let's do the last 4 decades, more or less, right, of our time, let's say from the 1980s onwards. Have the borders between adversarial and inquisitorial, between the common and civil law conceptions of the criminal process and the administration of criminal justice been blurring in the last 40 years? Well, there have been for sure a number of converging or convergence forces, if you want. Legal systems, administrations of criminal justice, governments face a lot of similar problems. They all want to avoid wrongful convictions, right, unless they have political trials, right? But, you know, at least for ordinary trials, they want to avoid wrongful convictions. They want some fairness, whatever that means. They want some efficiency, whatever that means. But the point is that they are looking for solutions, right, to address problems that at some level at least are the same problems. A second converging force is influence, right, that can be channeled and can happen, right, through different means, right? But in the same way that the French revolutionaries were fascinated, right, by English law, the Italian reformers in the 1980s were fascinated by American law. And then what we also have in the last few decades, and you know, we could do periodization there in different ways, is a common international human rights framework, right, that also could work as a convergence force, right, that would contribute to blur differences between the two traditions. So has there been such a blurring? Well, if we move, let's say, to the United States, where I live, very little. What do I mean by this? But what I mean by this, adversarial conception of the criminal process, right? The idea of the criminal process as a dispute between two parties before a passive court, of course, simplifying a lot, and we can unpack a lot, but lives very much in the practice of courts, in the procedural culture, and in the ideology of the system. If we think about the coordinate ideal and more popular conceptions of criminal justice, I think it also lives very much on, not only in for the fact that we have juries, right, but we have also other institutions very characteristic, right, of American law, very distinctive of American law, if not unique at times, such as the election of prosecutors and the election of judges. And even if the US has been facing problems that, at least some of them, are similar to the problems that other legal systems have been facing, like wrongful convictions, the US has not looked for solutions to these problems in civil law jurisdictions. No interest there. Of course, it has tried to deal with this in a number of ways, right, with different measures, right, from video filming of interrogations to the police carrying cameras, to new protocols for lineups, to DNA evidence, to, you know, standards to screen out expert testimony, to efforts to include the quality of experts and labs. But actually, in looking for solutions for the question of, or the problem of wrongful convictions, the United States has not been looking at civil law jurisdictions at all. Why is that? I think a couple of possible explanations there. The first one, that the The US, like any country, I guess, has had a relationship with the world that has evolved and changed over time, and today is not very interested, right, in what other legal systems may teach to the American system. And second, right, in terms of the international human rights framework, it actually has had very little impact and dent on the United States. If we move instead to continental Europe and to civil law jurisdictions first even than continental Europe, we actually find two different patterns, I think, in continental Europe and in Latin America. What do I mean by this? Well, if we start with continental Europe, of course there have been some very deep reforms, right, very much inspired by Anglo-American law, right, the Italian Criminal Procedure Code, right, of 1988, 1989 being a clear example of that. But for the most part, continental European jurisdictions, yes, they have received influence from American law and Anglo-American law. We can see it, for instance, in Le Plaider Coupable in France, right? We can see it, though, you know, it can be discussed, right? But with the German agreements, right? We can see it in, for instance, the regulation of the exclusion of evidence in Spanish law. We can see it in the adoption of the jury or re-adoption of the jury by Spain, right, in 1995. All of these, all reforms inspire directly or indirectly in Anglo-American models. And despite all of that, let's say leaving aside Italy for a moment, if we concentrate, let's say, in Spain, Germany, and France, they essentially have, none of them has introduced a deep reform to their codes. They have had the same codes, you know, Spain 1882, Germany 1877, well, France 1958, right? Though, you know, it's in many ways still the Napoleonic Code. And so the structure of the criminal process as an official investigation is still very much alive. If the same thing happens with the hierarchical ideal in this regard. Human rights, yeah, the European Court of Human Rights has done very important work, but overall leaving room to accommodate, right, different conceptions of the criminal process within its case law. If we move to Latin America, things are somewhat different, though. And I say this because even if it's hard to talk, and I'm going to talk about Spanish-speaking Latin America, not Brazil, nor other jurisdictions within the region. But if we talk about Spanish-speaking Latin America, the picture that emerges is somewhat different. It's hard to talk about the region as a whole because many countries, each of them with its own important institutions and legal innovations. But I think that one could try to describe at least some of the dialogue and some of the trends in criminal procedure and in evidence law in Latin America by, for instance, talking first about the model code, the Código Procesal Modelo para Iberoamérica, the model Iberian Criminal Procedure Code, right? That very much, despite its all its innovations, had a conception of the criminal process as a unitary, impartial investigation, a still model of official investigation very much present there, and very much also, with some caveats that we can discuss later, also has a very professionalized conception of the administration of criminal justice. There have been some reforms, though, that in contrast in the region have tried to move much more in the direction of the model of the dispute. And also, though I'm not going to talk about the latter, in the direction of the coordinate ideal. What do I mean by these reforms, or what I am referring to? Well, we have a number of codes in Latin America, with the Chilean code being very important in that regard, but the last 22 years, lots of things have happened and lots of new innovations have also taken place. But we see today in Latin America the adoption of new systems, right, that they are self-described as adversarial, and that in many cases involved parallel investigations between prosecution and defense, at least in some cases, that structure the criminal case, the criminal trial as a dispute, right, between parties, right, and there is the trial, the case of each party, right, as opposed to the case of the court, where direct and cross-examination are being used. And where there have been big efforts to eliminate the judicial dossier, to replace that with a system of pretrial hearings, right, as a way to strengthen the importance of the criminal trial. So in all of that sense, in Latin America, or the differences between adversarial and inquisitorial systems in Latin America, I think have been blurring much more there than, let's say, in continental Europe, for the reasons I just exposed. And then, just towards the end, right? I'm going to finish soon. And then the other twist that we could add to this, as a mode of a final reflection and as a mode of a conclusion, is something that I haven't been talking about yet, but which is the introduction of plea bargaining, right? Both in Europe, I mentioned it a little bit, right, regarding Europe, and now regarding Latin America. There is a paradox, and I'm going to end with this paradox with you. The paradox is the following. I think that some of the jurisdictions in Spanish-speaking Latin America that have done the most to strengthen the evidence, the importance of the evidence produced at trial, have been the jurisdictions that have deformalized the most the pretrial phase, right? That have made the largest effort to eliminate the expediente, right, the judicial dossier, and to create a system of pretrial hearings, right, and oral and public hearings before trial. One would think that this is good, right? Because one of the goals of these reforms have been to have a strong oral and public trials. But once we factor in the introduction of plea bargaining in the region and in these jurisdictions, things might look a little different than what we initially would think. And why do I say so? Because what happens with the introduction of plea bargaining in these jurisdictions is that, and around the world, is that the introduction of plea bargaining as a way to reach criminal convictions without a trial essentially entails an empowering of the police and an empowering of prosecutors. Why? Well, empowering of the police because criminal cases are now adjudicated typically based on the investigation done by the police. Why empowering of prosecutors? Well, because the role of courts and judges tend to be relatively formal, just checking the intelligence and voluntariness of the defendant's consent about the application of the plea bargaining mechanism, and therefore the decision, the charging decision by prosecutors often becomes the final decision, de facto final decision on the case. And the irony here is that those jurisdictions that have deformalized the pretrial phase the most screen then the work of the police the least. So paradoxically, those jurisdictions that have the strongest regulations to have a strong criminal trial might have the weakest mechanisms to screen the work of police officers. Thank you so much. I'm looking forward to your comments and questions.
No, you continue now. Thank you very much, Máximo, for this very inspiring presentation. I have the pleasure right now to present the next speaker. I know this is challenging. I'm requested for the possibility to have a coffee break in between, but the organizers recommended not to. So we are stressing upon your energy, patience, and forces. But so I give the floor straight away to our next speaker, who is going to talk about shaping probabilities between substantive law and law of evidence. But before he starts, I need to say some words. I'm presenting a little bit of the curriculum of Professor Poscher. So Ralf Poscher is professor of public law at the Albert-Ludwigs-Universität in Freiburg, Germany. And he's currently the director of the Max Planck Institute for the Study of Crime, Security and Law in Freiburg since he was appointed in 2019. So he's now honorary professor at the university, coping with the two tasks, which is already some assets to be underlined. After serving as director of the Center for Security and Society at the University of Freiburg until 2008, Professor Poscher has been also dean of the faculty at the same university and has been visiting professor at universities all over the world. Just to name some of them, Yale University or the European Institute of Florence or Japan, and etc., etc. He has published widely on constitutional rights, administrative law in Germany, as well as legal theory and legal philosophy, exploring also the role, which is, I think, it's also a core element in assessing evidence, the principle of proportionality in fundamental rights and the impact of artificial intelligence technologies on the understanding of the right to personal data protection. Thank you very much for joining us this afternoon. Please, Ralf, the floor is yours. Thank you.
Yes, let me first join all the other speakers in thanking you, Lorena, for organizing the panel, but also thanking the organizers for this wonderful, really, really impressive conference and for having me here and for giving me the opportunity to meet at least some of you and to meet new colleagues and people interested in similar topics. First, I wondered, how does my topic fit into the overall topic of our panel? I'm probably most concerned with the blurring of boundaries between substantive law and the law of evidence. And that has a very trivial reason. And that is because academically, the law of evidence plays a very subpar role in German academia, is my impression. And we heard this morning from Magne Strandberg a little bit about the German law of evidence and also some of the reasons why that might be the case. And I think one reason is that we have a very boring evidentiary standard. It's always full conviction, and it's always full conviction for criminal cases, for civil cases, but also, and that is closer to my home, for all administrative agencies and agents. They can only act if they are fully convinced that the conditions of the law have been met. So that's boring. It's always the same standard. And then the second reason is that we usually solve evidentiary issues by shifting burdens of proof. And that is also something Magne Strandberg mentioned this morning, we consider this to be questions of substantive law. So a lot of the evidentiary legal substance is in Germany discussed as a matter of substantive, not of procedural law. So evidence law is neither a dedicated subject in academic training, nor do I know many colleagues who specialize in it. Thus, also my contact as a public law scholar focused on constitutional law and public security law with the law of evidence as a field has been rather sketchy. There is, however, one issue for which I thought I had to jump to the law of evidence to get a better understanding of what is actually going on. And it concerns probability judgments in public law. And I might give you an overview over the presentation I plan, so you can kind of follow. So if you get a little bit dozy or something, you can just try to get a grip on where I'm in the outline when you listen in again. So in German public law, the most prominent area of substantive law that requires probability judgments is the police law that regulates preventive measures of police officers. And police law is at the heart of German administrative law and the administrative state. We teach it to every student of law because it provides the doctrinal basis for large parts of our administrative law. And it was developed by the Prussian High Administrative Court. So let me first take you back to the late days of Imperial Germany, to the teens of 20th century Prussia. On his patrol through one of the forests close to Berlin, a Prussian police officer discovered a little hut emitting a considerable amount of smoke. He looks into the hut, sees piles of sweltering Grudekoks. I haven't found a translation. It's a slow-burning byproduct of lignite coal. And he was afraid that sparks from this sweltering substance could cause a forest fire. Thus, as a diligent officer, he runs to the next telephone and calls the inspector of the regional fire brigade whether there is a risk of fire. The fire inspector identifies the substance as a special coal and falsely supports the officer's fear that it constitutes a fire hazard in the forest. The police officer rushes back and extinguishes the sweltering coal with a couple of buckets of water. The owner of the hut is furious because he correctly insists that the sweltering coal did not pose any fire hazard, since it just swelters for a long time and does not spark. So the owner sues the Prussian state for damage, because he used the coal to produce charcoal, and all of his production had been destroyed by the water. So the case comes in front of the Prussian High Administrative Court. And the court had to answer the question whether the officer acted lawfully by extinguishing the sweltering coal, since only if he acted unlawfully, the owner would have a claim to damages. Now, under Prussian and still under contemporary German police law, the police can intervene to avert a danger to public or private goods. Close to common usage, the term danger is defined as a heightened probability of a chain of events leading to a damage of public or private goods. So the Prussian High Administrative Court had to decide whether the hut with the Grudekoks, with the coal, posed a danger. And in accordance with common usage of the term, the court ruled that a danger requires a probability from the perspective of an objective observer at the time of the police measure. Since the sweltering coal did not pose a danger for sparking a forest fire, and a correctly informed observer could have known so at the time of the measure, the court ruled that the measure taken by the Prussian police officer was unlawful and granted the damage. Ever since, these type of cases have been discussed in the German administrative law literature. And one textbook example is one that the president of the Prussian High Administrative Court brought up in his first commentary on the Prussian Police Code from 1930, which is still the model police code for German administrative law. He imagined a staged execution on a film set in the 30s. And the police officer running into the scene unbeknownst of its cinematographic background. And well, in time of ubiquitous surveillance cameras and YouTube, we do not have to rely on fictive examples to jog our imagination. So we can listen to a small clip.
Things got a little confused today in one Long Island community as a mix-up over a movie location shoot almost got an actor shot. Rob Hoyle picks up the story from Belmore.
Here's a sneak peek of the independent film Jesse from a surveillance camera. Actors playing out a hold-up scene, a scene that looks so real the customers about to walk into the Cool Stop convenience store in Belmore, they dialed 911.
They saw people with handguns, people on the floor, other customers, people with their hands up.
The customers only saw the actor pointing a gun, not the cameraman or the sound crew who were out of view. The cops that responded weren't actors, they were armed Nassau County police officers, and they didn't have any movie script. Convenience store manager Sanjay Patel, who plays himself in the film, thought the cops with guns drawn were all part of the production.
They come inside, they grab the gun, and they yell it to the guy and say, "What's going on here?"
And you're thinking this is all part of the movie?
Yeah, that was the part of the movie. That's what I thought.
In life and in film, timing is everything, and that certainly proved to be the case here today. Had cops shown up while the guns were drawn and shots were being fired, who knows what could have happened.
The officer showed great restraint in disarming this individual, and nothing happened to anyone over there.
Detective Mike Bitsko says Nassau County welcomes filmmaking as long as the county, police, and town are notified. He says Director Fred Carpenter didn't have any paperwork.
It was on private property, but being that even though it was private and a local, busy street, I should have contacted the local police precinct.
In case you were wondering, this isn't Carpenter's first film. And just so you know, Jesse just happens to be about a Nassau County police detective. Go figure. In Belmore, Rob Hoyle, Pix 11 News.
Yeah, and thank you very much from the technical staff. It's the first time that I do this as it functions flawlessly. Okay, our modern day courts are much less strict with police officers than the Prussian High Administrative Court. In cases like these, they feel for the police officers and want to spare her the reproach that she acted unlawfully, at least if she acted with due diligence, as her Prussian predecessor did by calling the fire inspector. Thus, they modify the central concept of danger by not relying on the perspective of an objective observer, but by relying on the perspective of the diligent police officer. They admit that determining the legality of an official's action usually does not depend on the official's perspective. You don't owe a property tax if you are not the owner of a property, even if the tax officer has good reasons to erroneously think that you own it. However, modern courts think that the police powers relying on the concept of danger are different due to the inherent concept of probability inherent to the concept of danger. Probability judgments have a relativistic nature. They are relative to the information base. Thus, it seems a slick solution to come to rescue to the police officer by tailoring the relevant information base for the probability judgment to the things that she could have known given her circumstances. The probability judgment internal to the concept of danger becomes subjectified. According to this doctrine, there's already a danger if, from the perspective of a diligent police officer, there is a heightened probability of damage to public or private goods. Our contemporary courts point to the fact that police officers have to act under immense pressure and time constraints. When they see a gunman in the grocery shop, they cannot first go to the mayor's office and ask whether someone has registered for a movie shoot on the location. Thus, it seems only fair to the police officers to rely on their perspective. The courts are especially afraid if we were not to rely on the officer's perspective, we would paralyze our police forces in situations in which we might need them most. If a police officer has to think that his action is unlawful if he has not clarified the situation from all angles, she might be reluctant to act at all. When things get busy, they can never be sure whether their perspective matches the objective one. Thus, they could rather refrain from acting at all. What modern doctrine tries to do is to solve a matter of expediency via a subjectivation of the probability judgment in substantive law. And this strategy has its problems. The least of which is probably that the common use of the term danger is different from the one that our courts define it now. In the little clip, the actors in the shop were not in danger of being shot by the toy guns of their colleagues. Recent events aside, we would not say that someone aimed at with a prop gun was lucky not to have been shot. Some other problems might be internal to the German law and could be fixed in some ways, but at least in German law it is difficult to get compensation if an act of the police is lawful. And this probably motivated the Prussian court. Recent examples have been the mandated clubbing of a herd of perfectly healthy calves because the police had good reason to believe that they were infected with a contagious disease. The German courts switched on a dime, entertaining that for issues of compensation, the objective perspective were decisive. Also, tricky questions of self-defense arise. Let us imagine a less fortunate version of the clip that was alluded to by the reporter. Remember, he said, would the cops have arrived while bullets were flying or firing? Who knows what would have happened? Let's assume you are part of the crew and you see the police officer is about to shoot your main character. If the action of the police officers were to be considered lawful because from his perspective there is a clear and present danger that justifies the use of lethal force, it would be difficult to find a justification to intervene in the lawful action of the police officer. Even if you could save your main character by a slap on the wrist of the police officer who's pointing the gun, it would not qualify as a defense because you intervene in lawful action. There may be ways around this, and there are enough criminal lawyers in the room to be confident that some of you will come up with something, but at least it would be much easier and cleaner if we follow the Prussian court. My main point, however, comes down on the side of the Prussian court, does not focus on these issues, but raises doubts on whether the proposed solution is apt to solve the problem. Sure, police officers can reasonably err because they are under pressure and have to act with immediacy without ample time for further investigation. But this does not only concern the existence of a danger. The error might also concern the person responsible for the danger or aspects of the proportionality of the measure taken. Let us suppose a variation of the original Prussian case. Let us suppose the Prussian officer were correct in assuming that the Grudekoks, the coal, posed a danger of a forest fire. Let us further suppose that it would have sufficed and saved the production of the owner to close the doors and the windows of the hut to sufficiently suffocate the sweltering. But the police officer didn't know that because he had no expertise concerning the coal and used buckets of water just the same. He could not be saved by the subjectivation of a probability judgment because the proportionality concept of the least intrusive mean does not rely on one. What I took from this is that the issue that the courts try to grapple with cannot be resolved on the level of substantive law, and that the subjective probability that they introduced into the substantive law had been misallocated. Nevertheless, subjective probability seems to be part of the solution for scenarios like the one in question. And this now brings me finally to the law of evidence, where subjective probabilities figure as evidentiary standards. Looking at the situation of the police officer from the perspective of the law of evidence, their situation resembles the situation of summary trials when people seek temporary legal protection. Here, courts, like police officers, have to decide on incomplete evidence which is only to be fully explored in the main trial. How do procedural codes in Germany react to the predicament of having to decide on incomplete evidence under conditions of expediency? Well, in these situations, even the Germans lower the bar from the necessary conviction of the court, and they do so by not requiring the full conviction of the court, but solely rely on the plausibility of the claim, and it is considered that the claim is plausible to be sufficient to grant a temporary injunction. The police officers are in a very similar position as the courts. What they need, just like the courts, is a lower bar of evidentiary standard. They too must be allowed to act if the danger seems plausible to them. Thus, if we were to lower the evidentiary standard for police officers, they would only need a lower subjective probability judgment about the objective probability of a damage. So shifting the probability issue to the law of evidence in administrative law has two effects. Once, it leads to a subjectivation of probability, and it leads to a reduction of the evidentiary standard. However, just like the temporary injunction of a court protecting a potential claim does not finally support the claim, the lowering of the evidentiary standard for the police officer does not mean that the measure she takes has to be considered lawful. This depends, just as in the case of the claim, on whether the condition required by the law is not only plausible, but actually obtained. Thus, there can be no reproach against the officer for acting on merely a plausible impression of a danger, but the measure she takes is only in accordance with the law if the danger actually existed. So on the one side, the lowering of the evidentiary standard works against the fear that we would stifle the action of our police officers if we stick to the Prussian rule. And it would not only work concerning the requirement of danger, but also concerning the other requirements that police action has to meet. On the other side, sticking to the objective approach of the Prussian court in substantive law would avoid all the twists and convulsions that it gets us into with respect to damages, self-defense, and the rest. This is a very specific story to German law. So on the last part, I'm not really sure. Is there a general lesson to be learned? The answer will be specific, I think, to different legal systems, and thus I have to pose this question as an open question to you, the audience of specialists in evidence law from many different legal cultures. And since I'm also out of time, I can just offer a general take from my side. Be careful where to allocate your probability test standards when you're confronted with probability concepts in substantive law. You might have to take the law of evidence into account. Thank you very much.
Thank you. Thank you, Ralf, for this excellent presentation. I straight away give the floor to Professor Keil, Geert Keil, who will delve into the epistemological constraints on standards of proof and a short presentation, which obviously will not describe all his excellent academic career. And I will only say he's professor of philosophy at the Humboldt-Universität in Berlin and president of the German Society for Analytical Philosophy. And very shortly, his main areas of research are the philosophy of action, epistemology, philosophy of language, metaphysics, and the philosophy of free will. He has published books, among others, with the titles of Handeln und Verursachen, 50 Years of Quines, Two Dogmas, which is in language philosophy, as you know, one of the leaders, Willensfreiheit, so freedom of will, and more works on Quine, and Aristotle's Anthropology. I would say it's his last publication. Am I right? Or he has been so productive during pandemic that we can already add a new book. So I'll give you the floor, and thank you very much for accepting the invitation. It's an honor to have you here, Geert. Thank you.
Thank you for inviting me on hearsay evidence. As the sole philosopher among legal scholars on the panel, I aim to explore some parallels between pairs of related questions in epistemology and in evidence law. Actually, the intersection of both fields has become an own field of research, as you all know, which goes by the name of legal epistemology. Let me begin with some remarks on the general epistemological perspective on evidence. Epistemology deals with two main questions, subtleties set aside. First, what is knowledge? And second, what, if anything, can we know? As to the first question, the standard view is that in order to know that something is the case, you must believe that it is the case. Your belief must be true, and you must be justified in holding that belief. In a nutshell, knowledge is justified true belief. Now, the third condition for knowledge can be rephrased in terms of evidence. Being justified in holding a belief amounts to having good evidence for it. A pivotal question in recent epistemology concerns the degree of justification that is required for knowledge. Phrased in terms of evidence, what amount of evidence suffices to turn belief into knowledge? And you will recognize this question as one about the appropriate standard of evidence or standard of proof, legally speaking. Now, if you apply the JTB analysis with a low standard of evidence, knowledge comes cheap. True belief that is acquired with a certain amount of luck will qualify as knowledge then. False beliefs, however, never qualify as knowledge as a matter of linguistic fact. The verb to know is a factive verb, as linguists put it. Factive verbs take embedded clauses as their direct objects, and they presuppose the truth of the embedded complement. Here are some examples. The assertion, I didn't realize that Anna had left, is only true if Anna has left. And same for the verb to know. Now for the second option, if the standard of evidence is high, up to the requirement that the belief be justified beyond a reasonable doubt, knowledge becomes hard to achieve. Many philosophers say impossible to achieve for fallible human beings. This is the skeptical perspective on knowledge, the view that humans do not possess knowledge because the requirements for knowledge cannot be met. Skepticism about knowledge says that all ordinary knowledge ascriptions are false. This does not mean that most of our first-order beliefs are false. Skeptics do not claim this. How could we know that they are, if skepticism is true? Rather, they argue that even if many of our beliefs are true, their truth is not guaranteed by the evidence. This means that even for true beliefs, there are error possibilities that the evidence is not sensitive to. It might have been the case, say, that the fingerprints were left earlier on the firearm without our being able to detect it. In reality, it wasn't the case, but it could have been the case, and the available evidence didn't rule out that possibility. Here's a crisp argument for skepticism, an argument that shows how raised evidential standards relate to the skeptical challenge. First premise, knowledge requires eliminating all possibilities of error. Second premise, humans cannot do this. Hence, humans have no knowledge. Note that the first premise is a conceptual claim, a claim about the concept of knowledge. The first premise expresses an infallibilist conception of knowledge, the view that one can know that P only if one's evidence guarantees the truth of P. What could truth-guaranteeing evidence be? Videotapes of a bank robbery or of a convenience store robbery? But note that the skeptical argument is not about truth. It's about knowledge. The question is whether compelling evidence suffices to guarantee that we acquire a true belief. Fallibility, to be sure, is not a property of propositions or beliefs or theories. Beliefs are true or false. They are not fallible. What we mean by calling a belief fallible in loose speech is that the believer could easily be wrong about its truth value. Being fallible, the Merriam-Webster says, means being capable of making a mistake. In German it's the same, and in Spanish too, I was told. Accordingly, the second premise of the crisp argument for skepticism says something about us, about humans, and their cognitive abilities. It's a claim about the limitations of our power to rule out all possibilities of error. Forget about the conclusion. Skepticism is an artifact that follows almost analytically from an unduly demanding conception of knowledge. Skeptics employ an unsatisfiable standard of evidence and bite the bullet that humans do not possess knowledge. The real challenge for judicial fact-finding and decision-making isn't skepticism. It's the fact of human fallibility, the hardly deniable fact that for fallible beings, even the best available evidence does not suffice to infallibly produce true beliefs. Non-skeptical fallibilists, by the way, accept the second premise of the short argument while rejecting the first premise. Skeptics do it the other way around. Fallibilists about knowledge agree that knowledge requires true belief plus some evidence. Mere guesswork will never suffice, but they deny that the beliefs being true must be entailed by the evidence, because this demand is impossible to fulfill. That is, non-skeptical fallibilists, I think most of us are non-skeptical fallibilists, combine the acknowledgement of ineliminable human fallibility with a conceptual claim that knowledge does not require superhuman cognitive powers. Now, I announced that I wish to explore some parallels between pairs of related questions in epistemology and in evidence law. The first pair of questions is the one I just mentioned. What degree of justification is required for knowledge or for conviction, or more general, for establishing a factual claim in a trial? Legal standards of proof like clear and convincing evidence or beyond a reasonable doubt can be regarded as special cases of the general epistemological question: which amount of evidence suffices to establish a claim in a given context. The second parallel is that philosophers ask why humans are unable to rule out all possibilities of error, while legal practitioners face the challenge of avoiding wrongful conviction, and lawmakers have to codify the rules of procedural law in a way that minimizes that risk. And very plausible, even the best available rules can reduce but not eliminate the risk of wrongful conviction, and even less the risk of erroneous acquittals. These two parallels are rather elementary, but the third pair of questions is not. Philosophers wonder why it's so hard to produce a non-arbitrary threshold for the required degree of justification, the degree that turns merely true belief into knowledge, in a way that makes knowledge neither too cheap nor unattainable for fallible beings. In legal epistemology, the question is why it's so hard to specify what beyond a reasonable doubt even means. For example, to draw the line between reasonable doubts and unreasonable doubts, which need not be addressed, has often been noted that the word reasonable is not very informative. Here's an internet meme that a student once sent me about it. On the face of it, beyond doubt is a psychological category. In Germany, the Federal Court of Justice once ruled that what matters is the personal conviction of the judge. He has to make up his mind, quote, whether he can overcome possible doubts and convince himself that a certain fact holds, even if others would doubt or would come to a different conclusion. I think this formulation corresponds to what Jordi Ferrer calls the psychologistic or subjectivistic conception of proof, in which evidential reasoning is based on deep conviction or on the judge's subjective beliefs. From an epistemological perspective, a characterization of judicial decision-making that confounds psychological with evidential criteria does not capture the normative force, the normative pressure that the evidence puts on belief forming. The normative pressure is expressed by the principle of evidentialism, as it is called in epistemology. Evidentialism is a principle about rational constraints on belief-forming processes. It says that one is rationally allowed to hold only those beliefs that are supported by the best available evidence. And from this perspective, the psychological question of whether a judge manages to overcome his doubts is immaterial. Evidentialism is not a norm about what to do, say about when to reach a guilty verdict. It's a normative constraint on what to believe, a constraint that comes into play much earlier. If you believe on insufficient evidence, you are epistemically irrational, as Clifford's principle says, which is just a particularly strong form of evidentialism, Clifford's principle, as we call it, basically says that the norm of evidentialism holds without exceptions. And evidentialism points to a distinctive kind of rationality, epistemic rationality, that concerns belief-forming processes. Okay, let me return to my third pair of questions. On the face of it, standards of proof specify some threshold. In the American legal literature, you know, thresholds are often spelled out quantitatively in terms of probabilities. Beyond reasonable doubt, for example, is sometimes glossed as 90% or 95% likelihood given the evidence. Preponderance of evidence is interpreted as meaning at least 50% likelihood. Now, it's one thing to stipulate that a claim is established if the evidence exceeds some threshold. The challenge is to map the evidence in the given case to that threshold. Evidence comes in many forms: witness testimonies, documents, photographs, footprints, other pattern evidence, character evidence, and so on. In order to apply a numerical threshold, a scale is needed that can measure to which degree the collected evidence supports an assumption. There are some cases where the evidence comes with a built-in likelihood, that is, where there is a known ratio of evidential support between the evidential facts and the supported assumption. Take the notorious gatecrasher case, where the structure of the evidence is very simple. The probability in this case that an arbitrarily selected attendee crashed the gate is 80%, so that the preponderance of evidence standard from civil law seems to be met. These cases, however, where the only available evidence is statistical, I think are rare cases. In all other cases, where the collected evidence does not come with numbers on its sleeve, a standard like 90% likelihood given the evidence is hard to apply. Not because the likelihood is hard to figure out, but because there is often no fact of the matter about how probable a certain body of evidence renders an assumption. And if one claims nonetheless, in the absence of a known ratio, that a certain threshold is met, one creates a veil of pseudo-accuracy. So an alternative seems to be needed. Evidential standards must be spelled out some other way. And this has been done in recent legal epistemology. One approach is the relevant alternatives framework. Originally, this framework was developed within the theory of knowledge, namely as a reply to the question of how good a justification must be in order to turn belief into knowledge, and the reply is that depends. Depends on what? Well, on a number of contextual factors. For example, on how high the stakes are. High stakes require better evidence than low stakes. A case in point with excessive stakes would be capital punishment. The relevant alternative approach is an elaboration of this contextualist idea. It says that in different contexts, different error possibilities need to be addressed. Knowledge requires ruling out contextually relevant error possibilities, rather than meeting a certain threshold of justification. This approach nicely explains why the so-called skeptical challenge plays no role in the courtroom, even if the principle in dubio pro reo suggests otherwise. While the in dubio principle says that all remaining doubts must be resolved in favor of the defendant, it's silent on which kinds of doubts must be addressed. In the philosophy classroom, the context is such that you do not possess knowledge unless you can rule out the possibility of being deceived by an evil demon who is imagined to present a complete illusion of the external world. in the philosophy classroom, the evil demon is a contextually relevant error possibility. In the courtroom, it's not. Note that the threshold of probability model is inapplicable here. Let's, for the sake of argument, assume that Descartes is right, that we cannot rule out the evil demon. This does not mean that some quantitative threshold hasn't been met. It would be a pointless exercise to argue about how likely the existence of an evil demon is. The relevant alternative framework fares better. Its point is not that you can rule out the evil demon. The point is that you need not rule it out because in the courtroom it's not a contextually relevant alternative. So as for the beyond a reasonable doubt standard, the relevant alternative framework helps us to better understand how this proof standard is actually interpreted in the courtroom. Another alternative to the threshold model is the appeal to scientific explanations, as recently suggested by Jordi Ferrer in his contribution to the new handbook on evidential legal reasoning. I think it came out this week. In order to prove a factual hypothesis, he says, the hypothesis must be capable of explaining and integrating the available data in a consistent way, and any predictions of new data based on the hypothesis must have been confirmed. And second, all other plausible hypotheses that explain the same data must have been refuted. This is the highest standard of proof that he offers, his replacement for the beyond a reasonable doubt standard, as it were. He also offers a number of less demanding standards. Now, both approaches, the relevant alternatives approach and the scientific explanations approach, if I may dub it that, I think represent a step forward compared to the threshold of likelihood model. Let me close, however, with a comment on the aim to minimize in a systematic way the risk of factual errors. Take a look at the verbs. Hypotheses must have been refuted. Predictions must have been confirmed. Error possibilities must have been ruled out, says the relevant alternative approach. The verbs suggest that after you have done what the verbs describe, it's no longer possible that the ruled out alternative holds. The relevant alternative approach says there's a long list of sources of error, unreliable eyewitnesses, cognitive biases. Just think of yesterday's panel on factual errors. Now, you might think that once all these possibilities have been meticulously checked and ruled out, the evidence for P entails that P is the case. But this is not how it works. The picture is misleading. First, because the list of error possibilities is open-ended. And second, more importantly, because the idea of ruling out error possibilities puts the cart before the horse. Ruling out is itself a fallible epistemic activity. An everyday example. I've lost my apartment key. Where is it? I searched my pockets, I looked in the kitchen, I looked in the car. So these options are eliminated. Not so. As we all know, the key is found on top of the fridge, hence in the kitchen. I think the lesson from human fallibility is that no amount of evidence ever guarantees that a belief that is based on the evidence is true. Whether a belief is true simply does not depend on further beliefs. It just depends on what is the case. Nor does it depend on any amount of evidence that we use in forming that belief. So I'm reminding us of the fact that ruling out or refuting an error possibility does not mean that the possibility is no longer open. It just means that for all we know, it's no longer open. Okay, I'm fully aware that the focus on avoiding error ignores other non-epistemic aims of specifying evidential standards. And in law, one such aim is to distribute the risk of error between the parties. I think this fourth question that I won't address today about non-epistemic aims of evidential reasoning also deserves a synoptic exploration. Thank you for your patience.
Thank you, Geert. Last speaker, last but not least, of course. This panel has confirmed something which indicates it has been a good panel. Every time I confirm myself how ignorant I am, it means it has been an interesting panel and it was worth here listening to you all. Now it's the time to listen and address the questions of the audience. And once I manage the app, I myself have lots of questions, but I think it's absolutely polite to give first the floor to the audience. Allow me to just make an informal translation and change the order, or start with the questions for Professor Dyson. Do you think that one of the huge differences between, an important difference between civil procedure, torts, and criminal procedure is the fact that in criminal procedures there is the presumption of innocence and the public prosecutor has the burden of proof?
I'm going to say no, for a number of reasons. One, it wasn't solidified in English law probably until the 1930s, and I think we still recognize that there was criminal law before the 1930s, even if the presumption of innocence wasn't complete. I also wonder slightly what the presumption of innocence means. Does it simply mean that the state must prove its case, so it's a statement of who has the burden of proof? Does it also entail statements about the extent of what that standard of proof should be? So I think it's useful, I think it's relevant, I think a lot of people find it important, but there are things that I think I would recognize as criminal before we recognize that presumption.
I hope this satisfies the person who put the question, as we cannot have the feedback. I have a second question for Professor Langer. ¿Qué hipótesis explicativas tiene?
What explanatory hypothesis do you have for the paradox that the most robust systems with the trial guarantees are the least rigorous in the regulation of the regulatory in terms of the plea bargaining?
With higher fair trial guarantees, and they are less rigorous in their regulations and requirements for plea agreements.
Yo diría esto, sorry, do I answer in English or in Spanish? ¿Qué hago?
As you prefer.
For me it's the same thing. I would say this, because just for respect to my co-panelists. I am not talking about the level of rules. What I mean is I am making an argument about how we have rules that in some systems that essentially deformalize pretrial more, ¿no? O sea, tenemos reglas que deformalizan más la etapa de investigación preliminar o lo que se solía.
This is what we used to call the instruction.
of pretrial strengthens trial, ¿no? O sea, esa deformalización mediante reglas de la investigación preliminar fortalece entonces el juicio porque lo recolectado durante la investigación preliminar entonces tiene poco ser incorporado al juicio. But as a matter of fact, de hecho, once we have that deregulation, once most cases are actually adjudicated, most criminal convictions are reached through plea bargaining, lo que en América Latina se llamaría procedimiento abreviado, o bueno, hay distintas denominaciones en distintos países. Once that happens, once we have most criminal convictions being reached through plea bargaining, that pretrial phase that is deformalized screens out, checks less what the police did. Why? Let me explain it the other way around. So whenever we have a very formalized pretrial phase, then the prosecutor, the investigating prosecutor or the investigating judge, let's say, would call witnesses that the police interviewed to testify again before the prosecutor or the judge. That's a way to screen out what the police did. But once we have a deformalized pretrial phase, that doesn't happen. And so many cases are decided very early on based on these guilty pleas, based on these plea bargains, but without much control of what the police did. So it's a combination between the legal regulations and what then actually happens in reality, the effect that these regulations have then in actual practice. That's different from the question of what are the specific regulations to plea bargaining, the legal regulations to plea bargaining, right? That's different from it. So it's a combination again between that legal regulations argument and then their impact on reality. I hope that's clear.
Thank you. I would really continue with this discussion, but for me it's also a contradiction how it is implemented in the pre-trial stage for the plea bargaining. And
I think you agree with it.
Yeah, I fully agree with it, yeah. But it seems to be unbelievable. But I'll continue with the audience. Edgar Ramon Aguilera has asked for the floor. So if you stand up, someone will bring you the microphone. Can we see him? Yeah. Okay. At the very back. Thank you.
Hola.
Hello.
For this opportunity, so I want to address a couple of questions or comments to Professor Geert. I think that, well, I found your talk very stimulating. In fact, I myself am trying to follow the path of trying to use the relevant alternatives theory in order to cash out or to kind of define these mysterious phrases such as beyond a reasonable doubt. And I think that's the right path. But regardless of that, my comments are the following. It's just to follow up what you said about ruling out hypotheses. It's like there are by themselves standards of proof already built in this cognitive operation of ruling out hypotheses. So it's not just only that that our knowledge has limits. It is also that there are built-in standards of proof in the way we decide that a hypothesis has been ruled out by the evidence. So that's one suggestion. And the other has to do with kind of the normative evaluation of these kinds of proposals, because wouldn't it be very hard for the prosecutor or for the state if he or she were to rule out all the relevant alternative possibilities compatible with the innocence of the accused, but also consistent with the evidence? I mean, wouldn't that be too hard to do? And this is a practical concern, but I think that it puts too much pressure on the prosecutor, basically, and maybe that's something we want, but I think it puts on the table whether we want or not that kind of cognitive effort from the part of the prosecutor and the police in terms of gathering evidence with the capability to rule out all the relevant alternative possibilities. And I think we should reflect upon that. And the other one, the last comment, has to do with the relationship between these kinds of theories and a rather interesting and a very difficult cognitive skill, which philosophers call abduction. Abducing hypotheses, basically come up with conjectures or stories that better explain the evidence. It's a cognitive skill that we should be interested in trying to install it in our prosecutors or our policemen, etc. So the association or the relationship between these kinds of theories and the theory of abduction, I think it's something that we should be interested on also. So thank you.
Well, the acoustics on stage is far worse than it is in the auditorium. It's too bad for my kind of hearing loss. Well, the second part of your question concerned my last remark on distributing the risk of error. I took this idea simply from Geert's recent paper that I just read, and I think it's a familiar reaction from legal scholars that they grant the unavoidability of a risk of error, and say that evidential legal reasoning does not have the primary aim of reducing the risk of error, but the aim of distributing the risk of error between the parties. And I think there are analogous functions of evidential reasoning in other areas as well. I think burden of proof reasoning, and that does not only happen in law. It also happens when I've lost my apartment key. I blame my wife. Yeah, this is the first part of the question. Can you help me with one sentence or so to give me the gist of the first part of the question?
I lost track of it. You have to understand that the sound is not very good, but...
Funktioniert das so?
Ja, ja, funktioniert es so.
Okay.
Man kann es vielleicht viel besser hören.
Das muss wohl dran lassen, ja.
But then you will need...
Okay, please take the next question and we return to that later, okay?
Okay, we return to that question.
Gerd, lass es drin, lass es drin.
Leave the micro because you will need it later. In the meantime, I have a question for Professor Poscher. Do you consider that the lack of means of evidence and the protection of the public interest in the sphere you have described and in the examples you have put justifies reducing the standard of evidence?
Yes, I think it does, and there are different ways in how the law then again protects the public. For example, one point is that commands of police officers, they, at least under German law, but I guess must be somewhere like it in other legal systems too. They almost function like an intermediate judgment. So if the police officer is able to issue a command, even though he might be in error, accept very extravagant cases, you have to follow the command first and complain later, right? Because that takes the action out of the situation. So I think there are many ways in which the legal system is built up in our administrative law, how it can protect from the adverse effects that can happen. But you always have the possibility to challenge the action later. And there the bar is quite low. We have a general constitutional guarantee of whenever you are addressed in your rights, you have the right of your day in court, and every police action that addresses you can be reviewed by the court, and then it will be reviewed under these objective standards. And if the police was erroneous, then you can make that claim and will get a supporting judgment of a court. And that again then can lead that to, and this is a little bit how the mechanism works. Now you could think, well, then the police can do everything. That leads that the police has to adjust their behavior to whatever these court rulings are. What you do not get, for maybe people with a US background, you do not get damage that is worth pursuing. But you get your day in court and you get the court opinion, and then you can by that, by your court actions, influence also future police behavior.
Thanks. I think we can come back again with the question of Edgar, if you still have the microphone. Yes? Now that we have...
It's much better now, I can take questions now.
Yes.
Sorry.
If you can summarize it again, because, I mean, it was a long reflection.
No.
A very interesting one, but...
Thank you.
Sorry.
No, I just, well, the suggestion is that, do you think that in order to make it the theory of relevant alternatives more robust, could it be linked or somehow associated with abduction? For instance, inference to the best explanation, but mainly abduction. That's
I see.
That's the first suggestion. And the second was that, just to follow up what you said about ruling out, so when we think that we have ruled out a certain hypothesis, we're basically talking about the sufficiency of having ruled out that hypothesis. So we are introducing kind of from the back door a new standard or a mini standard of proof in terms of ruling out hypotheses. So just as this complicates matters a little bit more in the picture that you told us. Just these two comments. Thank you.
Yes. My argument was from the semantics of ruling out. The semantics of ruling out, or refuting for that matter, suggests that after you have done what the verbs describe, the possibility is no longer open. And this does not seem to be the case. So what we really do when we rule out error possibilities, plus using the inference to the best explanation, is not approximating truth, but we have a better justified belief. And so I think the progress that has to be made when we specify what is meant by the beyond a reasonable doubt standards, by using the inference to the best explanations model or the alternative, the ruling out alternatives framework is we have to somehow sever the link between justification and truth. Knowledge is justified, a true belief, but there is no direct link between evidence and truth. So the aim of our cognitive activities is not really knowledge, but better justified belief. Yeah? We have a better justification for our belief than we had before. And I think the standard of proof has to be spelled out purely procedurally. We have to employ certain procedures, but still I think this is common wisdom, we do not thereby minimize the error possibilities. And I think the mistake is the story around the alternative, the relevant alternative framework, that the mere semantics of ruling out error possibilities gives you the false impression that we can do this. We can't. We can ask, what do you mean? Fallibly ruling out error possibilities or infallibly ruling out error possibilities? And I think it's the former. Okay.
Thank you. I would give now the floor to Giannis. I'm sorry, because I'm horrible with names, but who asked the floor at the first moment, and I skipped him. So Dimitros Giannopoulos has the floor. Sorry, I didn't keep the order, because you were first.
Thank you very much. I have a comment leading, an observation leading to a question for Professor Langer. And it was thrilling to follow your analysis, taking us on a quick journey of converging lines across common law and European continental criminal procedures. So I would like to focus on your observation that European human rights, particularly the jurisprudence of Strasbourg, the European Court of Human Rights, has acted as an important convergence factor in European criminal procedures, though you have also importantly noted that there is scope for accommodation of different legal cultures. So I would simply like to add another two factors there that can help us further contextualize your observations. I would say that the first can be located at a single legal level, at a pure legal level, and the focus there is on the role that the Court of Justice of the European Union, and more generally, more broadly, European legal instruments, the EU directives on common procedural rights more specifically, now have as a force that runs parallel most of the times to the jurisprudence of the European Court of Human Rights. So in a way that is a positive force that can push forward and accelerate that travel towards convergence. And the second element in that equation is actually an opposite force and can be located merely and mainly at the socio-political and cultural level, and relates to the rise of populism, anti-European human rights, anti-cosmopolitan forces across Europe, and the way in which these can negatively, this time, affect this path towards convergence. And I will very quickly take two illustrations. In our common law, the common law part of the world, in Europe, England and Wales, and more specifically Brexit and the post-Brexit environment, where we are now actively considering, if not withdrawing from the European Convention on Human Rights, undermining the impact of Strasbourg jurisprudence in English law. And secondly, an equally powerful, I think, illustration, the threats and undermining, active undermining of the rule of law in European Union member states, such as Poland and Hungary, with significant ramifications for judicial independence. So the question is, what's next for the convergence of European criminal procedures against the backdrop of the forces that I have referred to? Thank you.
Great. So thank you for that. I take the first part as a comment, and I agree with all of that. What's next? It's hard for me to predict the future, right? I think, I mean, the world is very much at this point at a kind of a fork, right, between democratic institutions and non-democratic institutions, rule of law and non-rule of law, and the game is still being played out. So I cannot say more than that, but I mean, the same thing is true in Latin America, and the same thing is true in the United States, right? So I think that that Europe is not unique in that regard, right? It's more of a global trend and very much open in that regard. But thank you for the comments and the question.
Thank you. I will take two more questions. I'm reading here right now, one for Professor Dyson. Do you think that some of the substantive features of the law of torts justify certain features of the civil procedure that separate it from the criminal proceedings? For example, the existence of standards, variable standards, in the subjective systems of liability, negligence, and the presence of objective standards, strict liability. Would they make inadmissible a procedural design that would allow a kind of prosecutor accusing and investigating a particular individual? What other kinds of reasons will impact the procedural design of civil proceedings? You understood it, because this was kind of a very complex try to translate what I got here.
I doubt I will do it justice as a question, because it's a very rich question. Are there parts of civil procedure, are there parts of civil substantive law which express ideas, rules, principles which would necessarily play out in civil procedure, is what I took from the first half, and then there was an explanation of an example. I didn't really want to defend my potentially controversial opinion. I can say in English law, criminal law features strict liability, which is quite anathema or unknown, or certainly unliked in many civilian jurisdictions. And we don't have the same approach to subjectivizing negligence within criminal law. So on the rare occasions when criminal law uses negligence in English law, it does so essentially the same negligence that tort law would use, so not the standard that an individual could live up to, as well as being reasonable care. So I think if I recognize what we have as criminal law and what we have as civil law, I can't rely on some of the distinctions that would be used in civilian countries, some civilian countries. So I have to take away some of the factual basis which some might rely on for a distinction. But is there anything that I would hold on to for civil as opposed to criminal procedure, and particularly, for instance, evidence law? In some parts of private law, there are more powers to investigate. In some parts of criminal law, there are more powers to investigate and gather evidence. So there was a case a few years ago where a private party wanted effectively to buy the investigative powers of the Metropolitan Police. They said, if you, Metropolitan Police, investigate this particular activity and make available that evidence for us in the form of the types of financial investigation that you can get, which we cannot easily get in private law, we'll give you all of the compensation order that we get in a private prosecution. So that's clearly an example that a private party chose to go through a private prosecution, but to try to get the investigative powers of criminal law. So I think that shows us that there are some instances where private parties view civil procedure and civil investigative powers as insufficient for the goal they want. So at least there must be some differences that play out that affect legal actors' choices about how to litigate. Whether they should justify those distinctions, I'm personally not entirely convinced.
Thank you. I have still two questions asking for the floor. I hope I follow the order. Sebastián Rebolledo Aguirre, who is sitting where? Over there? Could you bring him the micro, please?
Hola, muchas gracias, profesores. Tengo pregunta compuesta.
Hello, thank you so much. I have a complex question here because it's for two panelists at the same time. And I would like to say something. Professor Poscher was making this example of the fire. So maybe we could just say that in an epistemic point of view, this is something future, something which might or might not happen. And also for Professor Geert, I have the same question. I mean, it's for both of you. In relation to the fire and the example, if we are thinking it's something which happens in the future, in German law, Professor Poscher, is there a difference from an evidence point of view how to take a decision if something is going to happen in the future or something is currently happening? Is there a difference from an evidence methodology point of view for future facts and current facts? And from the epistemologic perspective, is it possible to know these future facts? And many would answer no to that question, and I hope you will say no as well. So, which would be, according to you, the adequate methodology for taking a decision, reasoned and motivated and justified for future facts? Thank you so much.
Yes, thank you very much for this question, because it might allow me a little bit of clarification, because it's also sometimes confused in German law. If you what kind of conditions have to be met if the substantive law requires a prognosis, right? It is not that what is required is not that your prognosis is correct in the sense that the event that you prognosticize really occurs. Right? Let's say a storm is approaching the city, and you have this old guard tower where you do not know whether it will really make it through the storm. If you have to prognosticize whether people have to vacate the guard tower because of the storm coming, what is decisive is what at the point when you have to take that decision in order to avert that something happens to the people in the guard tower, what at that time would be an adequate prognosis in the sense that it would be justified by the evidence at that point in time to be that there is a heightened probability of the tower collapsing. If the storm passes the city and doesn't even hit it, your prognosis was wrong in the sense that the guard tower did not collapse. But that is not the kind of wrongness that the law is interested in. What the law is interested in, whether ex ante, at the point in time when you had to make the prognosis, that is a valid prognosis or not. And the validity of the prognosis is not put into question by the storm passing the city. But it would be put in question if you would find out, well, the static of the tower is just fine. There's no reason why people should be vacated. But it is not invalidated by the event. So you do not need insight into future facts. You just need an insight into justified prognosis at the point in time. And as the Prussian court thought, from the standpoint of an objective observer, not from the individual subjective standpoint of the acting officer.
As for the philosophical part of the question, can you have knowledge of future facts?
No.
I would say yes, if you hit the truth and if your evidence is good enough. Now, there's a prominent line that traces back to Aristotle, who says that contingent propositions about the future don't even have a truth value. Yeah? Sentences like, there will be a sea battle tomorrow. Aristotle thinks this is neither true nor false. We have to wait. I think this is clearly false. In 2014, in February, I told my students, and I had 100 witnesses, the final of the soccer tournament will be decided by a goal by Mario Götze against Argentina. And in July, after the final, they wrote me emails. Professor Keil, this can't be true. How did you know? And of course, I answered truthfully, I did not know. I just guessed. So it wasn't knowledge, but it was true belief. And the Aristotelians among us would say that we can have no knowledge about future contingent facts. I don't think that this is the case. In other cases, not Mario Götze cases, but cases where it's much more than mere guesswork, the three conditions for knowledge can be met. It must be a belief, it must be true, and I must have good enough evidence for it. This happens.
I would say that both your prediction and Götze goal was luck.
Yeah.
And that's a joke. I'm not talking in philosophical terms, but just in soccer-like ones.
The goal was not luck. My
fair enough.
The goal was perfect.
Professor Jordi Ferrer has asked for the floor.
Muchas gracias.
Thank you to all of you, the four speakers and the moderator. Thank you for organizing this panel. I wanted to comment on Professor Keil's presentation. And I wanted to mention a couple of things. Firstly, in my opinion, the evidentiary decision is a contextual decision. Secondly, it is a relative decision. It is contextual because the evidentiary sufficiency depends on the circumstances in which we have to make a decision. And those circumstances do not have to be with the case, but rather the type of case, for example. For example, the criminal decisions have a different level of sufficiency than in other cases. And within the same criminal procedure, we can even make further distinctions, and the standard of proof, the level of sufficiency, varies depending on the type and therefore is dependent on the context. But it is also relative. And relative to what? Relative to a set of evidence. And this makes it different from the epistemic decisions that are outside the judiciary procedure, outside the law. In this regard, I think that there's a specificity, probably the only specificity that differs from the epistemology in general. And what is that? We need to take into account the facts that justify the decision only with the evidence submitted into evidence. There are some exemptions and some specific facts, but we only need to account for the evidence that has been entered into the case. So in order to justify our reasoning, we cannot use beliefs and knowledge. We cannot use those two categories because beliefs are not relative. They are as if considered. I cannot have a belief for three evidence and a different belief for another thing. Because when I make decisions on a specific matter, I believe that the subject is guilty, but when I make decisions outside the process, I have more information that I was not able to use, and then I believe that the subject is not guilty. If I have more information, my belief also takes into account that my belief is all things considered. I cannot have different judgment on what belief is. This is part of knowledge, of the idea of knowledge, and therefore knowledge is not a category that I can use when making my decisions. I need another category that does not fall in beliefs and does not fall in the category of knowledge. So in the brilliant analysis that you presented, I think that there needs to be a different point of view that cannot be the categories of knowledge, justified beliefs and beliefs, because on the basis of belief, the evidentiary reasoning in evidentiary law does not follow that structure anymore. And before my second question, I wanted to add that, in my opinion, I think that we can include that type of reasoning with a different notion of acceptance that does not affect acceptance. It can be justified acceptance in light of the evidence that I have within the case. And acceptance, admission, is different from the beliefs, and it can be relative as well. And second comment or question has to do with that as well. And it has to do with your comment on that standard of proof one that I myself suggested in one of my articles, that I actually presented in this building, not in this room, but in the room next door back in 2018. In the previous evidentiary conference that we organized. Anyway, there I presented 6 standards of proof, and the highest standard is the one that you included in your presentation. And that standard of proof doesn't include the idea that the matter is closed, because the evidence is relative to the evidence that I have. Tomorrow I may have another piece of evidence that I do not have today, or outside the case there can be a piece of evidence that I do not have access to that may question the evidence that I have considered within the matter. So the fact that we have considered that in light of the evidence that we have within the matter, the hypothesis is refuted, that doesn't mean that this hypothesis cannot be open again in the future with new pieces of evidence. And not only because of that, but rather because the second clause in that standard demands that all other plausible hypotheses compatible with the innocence of the defendant are rebuked and as well. And how can we do that? Well, that depends on the knowledge of the world that we have today. And tomorrow we may have a different knowledge of the world. And the new knowledge might determine that we didn't consider another hypothesis. But that standard of proof says that when I made a decision today, in light of the evidence that I had today, the hypothesis was proved. But not tomorrow. If the set of evidence in consideration change because evidentiary reasoning is relative, so that relativeness, that relativity that is included in evidentiary reasoning, I believe that changes the paradigm in terms of if the standard fully closes the conclusion. It is fallible, and therefore I think that that is why we need the standards. Thank you.
Thank you. I couldn't agree more. I think on almost everything you said, my contribution was your philosopher's contribution. I was not even aiming at blurring borders between philosophy and legal scholarship. The hope is rather that we can learn from each other's perspectives on the topic of evidence. I did not suggest that legal scholars or legal practitioners are better advised to work with the concept of knowledge. I explored parallels between pairs of related questions in epistemology and in the law of evidence. And the first parallel, what degree of justification is required for knowledge and what standard of proof is required for conviction. Well, evidence is not only relative and contextual, as you emphasized. There's a further analogy. Both questions are clearly normative questions. They do not carry their normative implications on their sleeve, but on the most interesting readings, I think they are shorthands for the questions of what degree of justification or what kind of evidence should be regarded as sufficient in the relevant context. And in interpreting these questions as normative questions, I think we have ample opportunity to bring in the further factors, some of which you mentioned. Last remark on the weaker standards of evidence. I just told the audience about the first one, and you gave 6. I think the first or second question about the inference to the best explanation is fitting here, because if you do not exclude all other hypotheses, but do something weaker, as you do in the second, third, and so I think this, when I read it, looked very much like a strategy of inference to the best explanation. Would you agree? Or later this evening? Thank you for your question.
I would.
One more thing. Philosophers are having a hard time understanding the idea of proving a hypothesis that turns out to be false. The reason is simply that we interpret the verb prove like mathematicians do it. We have a hard time understanding that you can prove something false, but this is not your problem but ours.
I would continue this rich discussion and allow you all to continue. I have a lot of questions, but I think there might be, I skip them just not to force you to sit longer here. If anyone else has another question, otherwise we have until 6, but we do not have to exhaust the time limit. And I would say we can close this panel right now, unless anyone has a very important question. No? There's no false hypothesis to be proved?
That goal.
Okay. I keep my own questions for later, and I think during dinner might be even more interesting. I want to request all of you a huge applause for the speakers who have been excellent, incredible ones. Hey.